Well, so, we're going to start off this morning. They're going to put the teacher back on the stand. They're going to play that statement. When she was testifying on Tuesday, before things got complicated with this, differences in her original statement to police or to the Texas Rangers and what she testified to. And again, as I've said yesterday, memory's a funny thing. And she may and probably in fact believes that, but maybe she didn't tell them that originally. It's hard to say, or she's watched so much coverage that now she thinks that she saw that. It's hard. We want to believe our memories are photographic, but they're really not. It's not a.
Especially in a stressful situation, it's compounded. Your processing of what you saw then is complicated by the fact that you have adrenaline going. And now, like Rebecca said, she's been interviewed numerous times, so she knows the importance of what she says. And even if she doesn't know from an evidentiary standpoint what the ramifications are of what she says, she knows that she feels the pressure of that as well. So not only the traumatic stress of going through the event itself, but also the stress of, hey, I am a key witness in this case. I mean, even though this prosecutor may not have used those exact words, I'm sure she feels the pressure. Every lay witness feels the pressure of being subpoenaed to come to court, whether they're being forced to come or they're coming voluntarily. They know that the role that they play is very important. So she's also got that additional stress on her as well.
Well, and when she testified when she was testifying on Tuesday, one of the things that really just ripped my heart out was she was describing how the kids were out on the playground. She had her class, and there were a couple other classes out on the playground. Think about this. I have a kid. We all have kids, and your kids are out on the playground, right? And this situation starts to unfold, and she is getting the kids inside, and she's describing that she's kind of placing herself in a way to get them all in, and that really kind of places her in danger. And then she talks about getting scissors, and then how later she realized that all the kids had gotten safety scissors because they're gonna protect themselves. I mean, these are babies, right?
Right.
And they're getting safety scissors.
They're following her lead. I mean, she's their leader. They know that she's there to teach them, protect them. So yeah, that is very touching and so sad.
I know, and those are the things that when you think about what happened here, it's really hard. I hope I never have to imagine being in the shoes of these parents, because I've mentioned this. My kid at the time of this was the age of these kids, and I as a parent just it hurts my heart what happened here, and I'll in no way justify the police response on this. I've read a lot of the after action reports. I've watched a lot of the body cams. The response here was abysmal, and of course the question the jury will have to answer is that conduct criminal? And I don't know. It's going to be a really interesting question to see. Now, let's assume the jury finds him guilty. What implication do you think that has?
Well, you and I were kind of discussing this earlier this morning. I mean, you have to accept that, what is the chilling effect that's going to happen? I mean, police officers, they have such a stressful job as it is. Recruitment is something that is so important. I mean, you cannot go to a jurisdiction. I mean, I practice in Tarrant County, Rockwall, Waxahachie. I mean, every agency is hurting for recruits,
right,
for people to join the force. It's going to have it may have a chilling effect on that. I mean, yet again, not only are you signing up for a dangerous assignment, but now if you make a mistake at work, if you make a mistake in the line of duty, you may be, what are you going to do? That's going to follow you forever. You have to think about what the civil ramifications are. Professionally, what are the ramifications of that? They're asking you to voluntarily sign up for that. There's no amount of compensation that I think the average human would say is enough to be able to sign up to stick your neck out even further in a professional sense than you already are by signing up to be a police officer in the first place. And you've also got to think, whenever, I mean, I know that as a defense attorney, whenever there is an adverse ruling or an adverse consequence to a police officer on a force, there's ramifications for the entire force for that. You have to, you're allowed to cross-examine about that. If you have a police officer from that same agency in another trial, you're allowed to ask them, hey, isn't it true that, one of your own has been reprimanded for not following proper training? How do we know that you did that in this case? So it's just going to start a whole wave of things that would happen if they do find that the actions were criminal.
We've got a live look in the courtroom as we wait the trial to restart this morning. It's slated to start at 9 a.m. and there's former officer Adrian Gonzales, and I have to say he looks like he's got the weight of the world on him.
He really does. I mean, there's no telling what's going on in his mind. I mean, I just can't even imagine the whole world, essentially the whole world is scrutinizing that day you had at the office.
Yeah. Well, and it was a horrible day. And again, no justifications here.
Absolutely, but I can't even imagine.
Well, and the interesting thing about him, and it seems like the reason that he is, one of two officers charged. We also have the former chief of the Uvalde School District charged, which is Pete Arredondo. Adrian Gonzales is the first police officer to arrive on the scene. At the time of the shooting, he was assigned to the high school. He hears a call out over the radio, and we haven't heard the dispatch recordings yet as part of the trial, but I think the defense's argument seems like what I remember from opening statements is going to be that it was kind of unclear, what's happening. Some of this is, I think, going to go down to what did he know and when did he know it, which is why they're arguing he didn't have line of sight. And of course, the prosecutors are saying, look, he had an affirmative duty to go in there and act, and that if he had acted, he could have stopped the shooter from, if not getting in the building, being able to take over a classroom and kill 19 kids, wound 10, and kill 2 teachers. So, it'd be interesting to see how that.
Right, and I'm sure the defense will probably have police officer witnesses that say, look, every police officer approaches every scenario and every particular type of call differently. The training that you are to utilize, whether you're responding to a domestic violence case, is different than if you're responding to a disorderly conduct or somebody being loud or like a fight at a bar, things like that. I mean, a police officer can tell you just common sense. They're going to approach a situation if you need all of the information. And if you don't have all of the information, you are at a distinct disadvantage.
Right, and he is outgunned, right? He's got a a pistol or revolver. I'm actually not sure which kind of weapon he had, a duty weapon. The shooter had a rifle, and one of the things that they brought up in the testimony, I think it was from one of the DPS investigators who testified, is that a rifle round will, as one person told me a number of years ago after a horrible police shooting downtown Dallas where officers were killed, is that a rifle round will go through a regular bullet-resistant vest like butter. We say bulletproof vests, but they're really not bulletproof for a rifle round. And that's why, there's now a move towards the heavy vests. The heavy vests are the ones that'll protect against, and so they were waiting for shields and helmets and stuff. And of course, the argument from the prosecutors is every moment you waited is a moment kids died.
Right.
And that's
and did he know that? How are you going to paint the picture that he knew that?
I don't know.
Did he know that? Or when did he know that?
Right.
More importantly.
Well, and the body cam does show that he goes in the school. I mean, so what happens is he's the first officer there. Then other officers respond, Arredondo, and I think it's Sergeant Coronado. When it's Sergeant Coronado is the main body cam that I've seen. They hear shots, they enter the school, you see them go in, And I'm assuming they're gonna play this body cam as part of the trial, and you see him, them going down the hallway and approaching that classroom, and then he's kind of messing with his radio. What's happened is the radio's not working inside the building for, whatever, the signal, the walls, I don't know, but it wasn't working. So he goes outside to call for tactical. And then, of course, you have this ensuing extraordinary amount of time that the police officers do not enter those classrooms, which is, I find hard to justify. I mean, I don't think there is a justification for it. I've read through it. And as I was watching the body cam, Stephanie, I couldn't understand how they decided this was a barricaded person, right? Like, I'm like, how do you decide to handle this as a BP and not an active shooter?
I think that goes back to the fact that I told you I saw this in another program, that there was silence. I think the fact that there was silence at the elementary school, and I've seen the police officers interviewed about this, they thought that there would be screaming.
Right, but the kids are taught to keep quiet.
Exactly. And I think under the stress of the situation, maybe you're not processing everything like you should be in an active shooter situation. But consistently, every one of the officers that were interviewed in this particular documentary program said, we were just thrown off because it was complete silence. Right. But yes, just like you said, the children are taught,
to be quiet.
Exactly.
Well, we're seeing defense and prosecution entering the courtroom, and we're supposed to kick off here pretty soon. This judge runs a pretty tight ship. There's, of course, Adrian Gonzales again, as we await the start of day 3 of the trial. The first, because we had opening statements on Tuesday, and then we had this situation yesterday where we had this hearing, and then we're expecting the teacher to go back on the stand this morning here pretty shortly, and then they're going to, our understanding is, based on what we heard in court, is they're going to play the statement that she gave to police, and then there's going to be cross-examination, and then what's called redirect from the prosecutors, and then the judge will make a decision. I'm guessing at that point then the defense will decide whether or not they want to ask for her testimony to be stricken.
Correct.
And can a juror really forget what they heard?
Common sense would tell you no. I mean, just natural human response. Everybody keeps using the analogy of the unringing of the bell. There's going to be no unringing of the bell. But as far as the defense goes, they've got to do their certain steps to make sure that they are preserving the error for future appeal for their client. They've got to not only think about the strategy for this trial, but they've got to think ahead to his appellate rights in protecting the record for any type of appeal should he be found guilty and convicted. So they have to think about that too. They have to. And that's where the judge comes in too. I mean, I'm sure he's admonished the jury and told them before, look, anything that these lawyers say or when they object, that's not evidence.
Right.
Don't get irritated if we have to stop or take breaks or whatever, because this is, that's them protecting their clients' rights. So, it's very artificial, but there is a rhyme and reason for everything that they're going to be doing.
And I know from having interviewed jurors after cases that jurors really take the responsibilities so serious. I mean, I interviewed for a case I worked on. It was a big case. Interviewed several jurors afterwards, and the enormous responsibility they felt. And the jurors are instructed not to discuss the case while the trial is going on, and they were talking to me about how they talked about everything under the sun but the trial, which that would be enormously difficult. But in the course of that, you actually get to know each other.
Yes.
Because you can't talk about the thing that you're all sitting in all day, so you learn about each other's kids and families and everything else, and which probably leads to some bonding, right?
Yes, very much so. They become very, very bonded. I mean, as you've seen, like high-profile cases, some of them go on to write books. If they're in really popular cases, Yes, they become very bonded. I mean, they're hearing a lot of traumatic things. I mean, how can you not? How can you not cling to the people that are in the same situation that you are? I mean, nobody else, there's nobody else in the world that's going to experience the case the way that you experienced it being a member of a jury. So you're right. I mean, it's only natural that you take that common thread and you do become bonded with somebody because there's nobody else that sat in the same position that you did.
No, and the responsibility here is big because this is the first time under in the state of Texas that an officer has been charged under this statute in this way. The only other similar case that we are aware of is, of course, from the Parkland shooting, where the officer in that case was charged and tried and found not guilty. Now, it was the laws in Florida are a little bit different, but the circumstances are. It's the closest thing that I'm aware of to what we're seeing here, in this courtroom in Corpus Christi. But one thing I thought was really interesting was when all this situation arose with this teacher, Rebecca texted me some information about Judge Harrell, and I was shocked when I realized, we were both shocked when she figured out that he was the judge in that Michael Morton case, because of course Michael Morton is what leads to a sea change in the way that prosecutors' offices are required to disclose discovery.
Absolutely. And just to kind of bring everybody up to speed, practically, I mean, I've been a defense attorney since, I started out as a prosecutor from 1997 to 2002 in a smaller rural county, which is actually not small anymore, Parker County. And then I went on to be a municipal court judge, so I signed warrants and things like that. But the rule used to be, and this is why it's so different and why a lot of people, maybe old habits die hard, is every county had a different policy about whether they had open files or not.
Right.
Before that, we all had to file motions. And not only did you have to file a motion for discovery, but you had to have a hearing and you had to get a ruling. So all of those were steps that had to be done, because if you didn't do those things, then obviously the prosecutor wasn't in any obligation, because you didn't do your due diligence to ask for those things, to follow through, to get a hearing and get a ruling. Well, once Michael Morton came on, the burden shifted to the state to do those things for us. And not only did they have to just open their file and make it available to us, but they had to affirmatively tell us, here's what the situation, here's how much it is. Here's where we've got the copies in here. A lot of jurisdictions, Collin County, for example, really good about first setting. They've got your discovery there for you. They're telling you everything. I mean, there's some. Well,
that doesn't surprise me. Bill Worski's in charge up there. Well, not in charge. He's the second in command, and I've known him for a long time. That doesn't surprise me.
There are some counties that are very, diligent about it and get it done like right off the bat. But as far as, and I can tell you too, Dallas County, if there is anything that they're disclosing, it is not uncommon for us defense attorneys to be presented with something in writing saying, can you please sign this, acknowledging that you received this, that we've told you there's been a problem in the lab, or there's been a problem with this particular police officer. Not only is there written disclosure of it, but they will have us as defense attorneys acknowledge that so that they can
It's protection for them.
Absolutely, absolutely. So there's mechanisms in place for people to avoid arguments like this being made.
Well, and I think that, under the old system there was, and it's not to say that some of this doesn't still exist, there was such a get the conviction almost at all costs. And it led to some pretty horrific wrongful convictions. And of course, Michael Morton was a man who spent decades in prison for the murder of his wife that he didn't commit. And, evidence that should have been turned over but wasn't turned over, could have led to him not spending all those decades in prison. And of course, we saw over the years, like you have been doing this a long time, and when I first started, covering law enforcement, the way lineups were handled was very different. It wasn't uncommon in the old days for, the detective to show a 6-person lineup and the person that was the suspect to look really different than the other ones. And of course, okay, we're starting to get sound in the courtroom. I think we're about to start.